have the one item on the agenda tonight, the Cedar River Library update, and I know we're anxious to see how this is going. So with that, I'll turn it over to somebody on staff.
Let me
Larry.
start out, if you could, please. Just as the council knows by now, there's been an appeal filed in this matter, and the rules are become a little strange at this point, so I wanted to explain things just a little bit. The council can be the appellate body after the hearing examiner if after the examiner rules, someone appeals to the council, so you could be put in a quasi-judicial position then. But we're only speculating that that might happen, so you're not in a quasi-judicial position yet. So you're able to act as normal council members right now. However, there's always a big however or but involved. During the interim period of time, if you make any statements that indicate that you have prejudged the issue that will be within the appeal, or any of the issues within the appeal, or you can't exhibit independent judgment on the matter, then that would be a violation of the appearance of fairness doctrine. So I would caution you to be careful during the interim period of time, and if I was in your position and somebody approached me about it, I would politely listen and indicate I'll take your comments under consideration, but I don't think I'm free to express an opinion right now. At the hearing, there's ultimately, if it comes before the council, if you handle it the normal manner, it goes to Planning and Development Committee, then on to the council. There probably will be a question asked if you could be fair in listening to the appeal, and I anticipate completely that all members of the council will be able to indicate that they could be fair and hear the appeal impartially. Just so that there's another item I just want to mention, and this is more for the general order and for those who might wish to address the council, but with respect to any of the items that are on the appeal, any audience comments that are made to the council are not part of the record, and the record will be made in front of the hearing examiner and not by council. So if you hear anything at this meeting or another later meeting that would bear on the appeal, I most likely would have to instruct you to unring the bell. You can't consider those matters that you've heard that are not part of the record. Now, I know that's extremely difficult. Where did I hear that? Was it part of the record? And that's part of my office's job, is to try and guide council through the record if the appeal should come to them. So those are, because it's a very unusual situation, we're having a briefing that we might not normally have at this point. I thought it best to address those comments. One other thing, the staff briefing tonight will be limited strictly to the items that are on the record, without any argument as to the merits of the appeal. I mean, this is just like Dragnet and Joe Friday, for those of you that are old enough to remember that. Just the facts, ma'am. It's just the facts, ma'am. Ma'am, just the facts.
And nothing more.
Yeah. But half the people don't understand that. That comments got to be a little older than the average.
I love that show, by the way, Larry.
Yeah. Good. I did too, Mr. Corby. You just couldn't get Joe Friday's demeanor, but then, his sidekick turned into Colonel Potter
Yes.
on MASH, and
Yeah.
it was quite different. So we'll really visit some old territory here and see how much time I can
Yeah.
waste. So I just wanted to lay that out for you. So tonight's just the facts, ma'am, and your role is not changed, but you're going to have to be careful until the appeals are all over with, to make sure you don't say something that's too untoward that indicates you've made your mind up one way or the other. I'm sure you'll all be fair-minded.
And Larry, can I just ask for a little further explanation for me and the benefit of others listening in? So the the appeal that's been filed would go to the hearing examiner. Is that correct?
Yes.
Okay, and then, but then if the hearing examiner's decision is appealed, it would come to the Planning and Development Committee of the council
If you-
to hear it, and then they would make a recommendation to the full council.
That's your normal procedure, yes.
And then in the quasi judicial role, we as council members would be rendering really basically like legal decisions, not, we wouldn't be deciding based on our opinion of things. We would be looking at
Right.
the policies and the letter of the law and doing our best to act like, almost like jurors or,
Yes, so like judges. The way the code is written, you would have to find a substantial error in fact or law in the decision of the examiner.
okay. Okay, good. And so, and then with regard to the record, the record for the hearing examiner, has that been finalized and closed? Is that or is it,
No.
the hearing hasn't happened yet, so that
Right.
record's still open at this point?
Yes, there's going to be a dual hearing, a land use hearing on site plan approval, I believe it is, and then there is an appeal on the environmental determination, the mitigated declaration
Okay.
of non-significance. So those will be held back to back, and they're completely different hearings and different burdens of proof, and so they're two hearings combined together.
Okay. Very good. Thank you.
Mr. President, Randy?
Yes.
If I may, as Chair of the Planning and Development Committee, since we haven't heard anything about the potential appeals and we don't know what the hearing examiner will rule, and we wouldn't know who the appealing party would be, and again, so a completely blank slate, I know at the time as we get closer, but I'm thinking now might be the time, is that it doesn't make sense to me to just have the Planning and Development Committee hear the appeal. I think the whole council should hear the appeal, regardless of who it is that appeals, since it's a topic that all of us are interested in. And I think if we can just get, I see head nods, why don't we just plan on the entire council taking the appeal, Larry, if that's a
Well,
possibility?
the way it's normally done is it's referred to the council as a whole, and the council's general procedural rules is you refer to planning and development, but they're your rules, so you can change them any which way you want. So I think you get a pretty clear indication, and if we got an appeal from the hearing examiner's decision, we'd have a little discussion with the city clerk that the council wishes it referred to the committee of the whole, and we'd go that way.
Right, and that's why I'm saying to kind of tackle it now, because the city could be the appealing party, or library people, or the Michael Schutz, or, and that type of thing. So I think we can take away any appearance of bias or anything about, well, are they putting it in committee, or are they taking it out, by just kind of agreeing that we would just hear it as a council. That's my suggestion.
I think it makes sense.
Yeah.
One other thing that I just wish to mention is that to make sure that all council members had all of the documents that are current and recent, there's been a lot included that kind of got dropped on you a little bit today, but we have Muckleshoot's comments and a couple comments from, a comment from the state archaeological office and one from a private historic preservation trust. And we just wanted you to make sure the full council had all the documents that were out there right now. So we don't want to have you try and wind your way through what the merits of those documents
Yeah.
might be,
Yes.
but just information.
Mr. Chair.
Is Ms. Breyer?
So these are all part of the record that the hearing examiner has examined?
Yes, they are.
Will examine.
Or no, will examine.
Will examine.
Sorry. They're in the
Okay.
public record right now. They're part of
All
the
right.
official file. They're open public records. So that's all that's been distributed.
Okay,
Okay.
Mr. President.
Staff's presentation will try to put those into context for you.
all right, thank you.
And just one, well, I have just one final, so the council will make, there's no decision for you to make. This is,
Right.
technically,
Right.
this is not before you. This is really information for you to have. You made your decision, it's been moved on through the process to the hearing examiner, it's now before the hearing examiner. You may not ever have to make another decision. We just wanted to give you information. If it gets appealed back to you, then you may hear it again. But, there may be some angst about the volume of information you got late in the day, but again, we will try to give you a summary of what that information is. No decisions by the council are expected or needed or in fact warranted tonight.
There was some thought given to simply submitting all of that material to you via an email or some other means without even bringing it into tonight's meeting, but just for the sake of completeness and clarity, we thought it should be submitted tonight, so.
Yeah. Good. Mr. Taylor, did you have a question?
Yes, just given the, the advancing of this briefing tonight and, advance of the hearing examiner's decision on this item, just as it goes back to interactions and communications with community members who may want to engage in discussion about this. I just noticed that there's a few other people came in again. Would there be any advice that you could render to our community members in the sense of the position that we're in right now, in terms of really not being able to discuss the matter until there's been a rendering by the hearing examiner?
Yes, the council should not, while you're still in your role as council members, you may certainly listen to citizens that wish to address you on it. You should not express any opinion about the merits of the items that are on appeal. Now realize the items that are on appeal are pretty much limited to what is in the appeal letter. They are what's in the appeal letter, and I'm not going to try and characterize those for fear that I might mischaracterize them, but they're not extensive. So to the extent that you're asked to express a position on any of those particular items, my advice to you would be not to do so, because you will be disqualifying yourself from a later appeal hearing on the basis of prejudgment or lack of appearance of fairness. So just be cautious with that. I know you all want to and look forward to sitting as a quasi-judicial body.
It's so much
And
fun.
I got some rueful grins from that, but it's one of your tougher jobs because it's not your common position as council member.
Yeah, and Larry, I'll maybe add to that. I just say some things that I think Mr. Taylor, I'm sure Mr. Taylor is aware of, but just for the benefit of the audience, which is maybe a different group of people than have been here for other issues. So the city has made a choice in past years, and we've revisited it from time to time. With hearing examiner decisions, we could have chosen as a city to always have those decisions appealable directly to Superior Court. There's the upside of that is the council would never have to sit in a quasi-judicial capacity. That's kind of confusing because most of the time we're political people and we interact with the public, and it's what we do. When we're in the quasi-judicial role, we have to specifically just look at the written record and look at the rules of law and serve like judges. The upside of having decisions appealed directly to the council is that a citizen who maybe is concerned about a project in their neighborhood that doesn't like the way the hearing examiner handled it can actually appeal without having to hire a lawyer and go to Superior Court. So they can come to the council and have that decision heard in front of the council as a quasi-judicial body. And it's much faster and it's much less expensive. And so normally it works well, and it's a neighborhood here or a driveway there or one thing or another, and most of the community's not even aware of it, and it comes and it gets appealed. This one's going to be really strange because it's an issue that it affects a library that's been in front of the voters a few times recently, and everybody's got an opinion on it. And so people are going to be kind of confused as to why the council's suddenly saying, oh wait, we can't really talk about that. I'm frankly not looking forward to that kind of unusual position we're going to be in, but it is what it is. And I think we'll just probably need to continue to get guidance from week to week from the city attorney about how we handle that.
Mr. President, if I could just add to it, maybe I think get at a little bit what Councilman Taylor was asking as well. This is also confusing for the public.
Right.
So they're used to coming to you and being able and to try to present information that they think will help clarify. In this case, anything they give you from here on out is not relevant to going forward. They could stand up and talk to you for hours. You can consider none of that if this comes back to you. You'll only be able to consider what is presented to the hearing examiner on the 30th, and then should that decision be appealed, what is on the record from the 30th.
Okay.
So if people want to come up and and try to give you information tonight and in the future. It's simply information that you can't consider.
Okay.
Should it come back to you as an appellate.
Okay, so put another way, if it's relevant to the issue that's been appealed, the place for it to go is to the appellant to present to the hearing examiner, and we would get it through that channel. It would become part of the written record.
Right, Mr. President, and that was the piece that I was hoping that we could make more
Yeah.
clarification of, because this could be very confusing to our residents, and it could also create some frustration in terms of why we can't, I mean, this whole library issue has been somewhat, interesting all by itself, but now that we add this element to it, it can create more. So I would recommend that we figure out some ways that we can better communicate that to our residents so that they are aware that they shouldn't even come to us to want to have those conversations about that and know why.
Okay.
Mr. President?
Yeah, Mr. Person.
Well, to further kind of confuse the issue that's been brought up, and the question for Larry is, so at audience comment at the council, I mean, somebody gets up and makes an impassioned plea for whatever reason, and I know there's been an appeal, and I don't know what the basis of that appeal. I haven't even had time to look at any of the information we've been given. So, but if somebody makes a passionate appeal on audience comment, then you're telling me that that can't be considered by the council.
Exactly.
Right.
So,
Unless they are able to present the same information to the hearing examiner, they're part of the appellant body, and make that same plea, it would come to you once through your ears, you would disregard it, and once through your eyes, because it'd be part of the record.
Right.
And you could take it into consideration. So it is a bit of a strange process.
Mr. President, so that brings up, what I think might be an answer, that maybe, we should mention to people during audience comment period, that if they do want their comments to be before the council and during this hearing, that they should follow up after their audience comment by making sure that information does get to the hearing examiner.
Yes, sir.
And they could submit those comments in writing, and do they have to be at the hearing, or can they just submit it in writing?
The comments can be submitted in writing through the appellant.
Through the appellant, that's right, good point. Okay, good. Okay. Well, that was
So
interesting.
that was simple. I'm glad we had this moment to
Yeah.
chat before we had this presentation.
Thank you, Larry.
I
The
tried to
topic
take
wasn't
it away.
confusing enough, so we needed to add that dimension. All right, well, with
Okay.
that, thank you.
So in an attempt to follow all of these regulations, as we've just discussed, my presentation, once again, is all within the record as it currently exists for this land use application. And I will kind of go through all the materials that you were provided on a high level, and the intent is to stay with 100% within that record. Okay, if we can make this move. Oh, there we go. Okay, so just a little history. The application for the permit, the land use permits, was submitted to the city originally on March 1st. This application was determined to be an incomplete application on March 26th due to the fact that council had not yet approved the design of the library. So following that, there was a revised submittal that was submitted to the city on May 10th, and the application was determined to be complete following that, which was on May 29th. Now, on May 29th, that started our public comment process, and it's a 14-day public comment period, which ended on June 12th at 5:00 p.m. And those comments are all submitted to the planning department. And for the record, I'm Vanessa Dolby, senior planner. Hadn't put that in the record yet. So they all were submitted through me as part of the land use process, this is all typical land use process that would have happened for any other land use application that came to the city that required the same permits as well. So the permits that they are required to receive, one is the SEPA environmental review, which has a decision that's made by our environmental review committee. The second is a site plan review, which the decision is made by the city's hearing examiner. And then they also are required to get a shoreline substantial development permit. That's an administrative decision that gets sent to the Department of Ecology. And then finally, they will also need some building and construction permit approvals in order to move forwards with the project. So as I mentioned, we had the 2-week public comment period. There were some comments that were received. I have to say I'm going to go through each one of those. You have a copy of those and some correspondence that goes along with them. Oddly enough, none of those comments were received within that comment period window. The first comment is the Muckleshoot Indian Tribe Fisheries Division. That comment was received on June 12th, which was after the comment period, but just barely. It was before our SEPA determination was issued, however. And this comment focused on a number of items, including artificial lighting, and they did request a copy of a lighting plan. They also requested a copy of the stormwater report. They requested the creation of a wood management plan to deal with logs as they come down the river and maybe hang up on the pillars. They also addressed concerns about the gabion baskets, which are currently located within in the Cedar River as shoreline stabilization. They expressed some concerns about construction noise and also about the shoreline mitigation fee in lieu, not as it relates to using that, but as it relates to the dollar amount identified in the application submittal. A second set of comments was received from the Department of Archaeology and Historic Preservation. These comments were received on June 26th, which was after the close of the public comment period and also followed the determination that was issued by the Environmental Review Committee. These comments focus on a couple of things. The first is archaeology and historical resources. They identified that 10 recorded resources were located within 1 mile of the project site. Several of those are located within half a mile, so a little bit closer. And then 7 of the recorded 10 resources were archaeological sites and/or cemeteries. And they did request that an archaeological survey of the project area be provided prior to any ground disturbing activity. Due to the timing of the comments, we did include in the staff report to the hearing examiner that you also have a copy of a recommended condition that the applicant does complete that archaeology survey prior to any ground disturbing activities. Now, a decision hasn't been made on that because that will be made by the hearing examiner, but it's recommended at this point in time. So the same comment continued. They also focused on the more historical architectural standpoint, and they mentioned that the building is a good example of mid-20th century modern architecture and landscape architecture, that it exhibits World War II era modernist style, and they recommended that the library board, the city, or other interested parties explore ways to capture the building's contribution to our local history through ways such as interpretive displays, either landscaping, public art, or recycling building elements. And they also included a reminder that if there is federal funding in the project, we have to comply with federal regulations, and there is no federal funding involved in this project. And then a third comment was received from a nonprofit identified as Washington's Trust for Historic Preservation. This comment was also received after the public comment period on June 21st and also after the SEPA determination. It focused also on the historic architectural standpoint of the building. They provided a copy of a letter from the Department of Archaeology and Historic Preservation that was addressed to the Friends of the Cedar River that talked about the library and the surrounding areas as having eligibility for a National Register of Historic Places. They expressed a hope for rehabilitation of the existing library in a manner that is historically appropriate. And they requested mitigation for the loss of a historic structure in the form of documentation of the library on the National Register of Eligible Sites, retention of certain features of the library, including character-defining features present in the interior of the building, and then a survey of post-World War resources that are also located in the city. So we did issue an Environmental Review Committee report. Now, this report was issued prior to the receipt of all of those comments with the exception of the Muckleshoot Tribe comments. And the purpose of the report is to substantiate and disclose the environmental impacts of the project and to identify mitigation to reduce any significant environmental impacts. So the staff report's divided into 2 parts. You have a copy of that staff report. The first part is a project description with background information as submitted by the applicant. The second part addresses only those project impacts that are not adequately addressed under existing development standards or environmental regulations, i.e. Renton Municipal Code or state regulations, and that is consistent with state law. So I'm going to go through all the elements that were addressed. So we looked at earth first, and it explains the conditions as it relates to the seismic hazards and the seismic hazard evaluation of the site. And it does include a recommended mitigation measure to provide compliance with the geotechnical analysis that was provided with the application. We also looked at water, and we looked at not only the Cedar River, but also stormwater. The report explains conditions as they exist and as proposed, evaluates impacts to the stream, identifies proposed mitigation, and addresses the Muckleshoot Indian Tribe comments, and includes a mitigation measure to comply with the stream study that was provided with the application, which has a number of mitigation inside that. The stormwater evaluates the existing and the proposed stormwater, and that was included with a technical information report or a stormwater report that was provided with the application, and it identifies what proposed mitigation has been provided. Vegetation section explains conditions existing and proposed and addresses tree retention. The wildlife section evaluates a habitat data report and the stream study that was provided with the application, identifies listed species in the area, and proposes mitigation for potential impacts, includes the mitigation measures to comply with the habitat data report. We looked at light and glare, evaluating interior and exterior lighting, and proposed mitigation for shielding of that lighting for impacts on potential fish, but balancing that with public safety needs. Park and Recreation section evaluates temporary construction impacts that will happen in Liberty Park. And then Transportation section evaluates site access and vehicular trips associated with the project. So following that, the Environmental Review Committee did issue a determination of non-significance mitigated, which is your DNSM, and that was issued on June 17th. And the determination was published in the Renton Reporter on June 21st. Public notice posters were placed around the site, and all parties of record and appropriate agencies were notified of that decision. The appeal period for that decision started on the day of publication, which was June 21st, and ended on July 5th at 5 p.m. And as you know, we did receive an appeal on July 5th at 4:32 p.m. So looking at the appeal was received from the Citizens to Save the Cedar River Library again, and it was signed by David Keys, Beth Asher, and Nicola Robinson. And the appeal requested two things: either one, the proponent of this project be required to submit a full environmental impact statement, or the project as proposed be modified to directly address and mitigate its likely significant environmental impacts. And as Larry mentioned, I'm not going to get into the details or of that, but you do have a copy of that, and staff will address that appeal at the public hearing on July 30th. And as I mentioned, the public hearing, we did have a public hearing originally scheduled for July 9th. Now that hearing, as you know, hasn't moved forwards due to the receipt of the appeal. We've extended that date out to July 30th at 10 a.m. in order to allow some preparation time for that appeal. And staff does typically provide a recommendation to the hearing examiner in the form of a staff report, which is that hearing examiner report you received a copy of. That is issued 1 week prior to that public hearing and is sent to the hearing examiner as well as parties of record, so they have the opportunity to review that before the hearing. Because the original hearing was scheduled July 9th, that report's already been issued and mailed, and it was issued and mailed on July 2nd. And in that report, there is a lot of information, but the idea is to provide a recommendation of either denial, approval, or approval with conditions. And the report includes an analysis of everything you see on the screen here, including such things as compliance and consistency with the comprehensive plan, zoning regulations, design regulations, etc. And then next steps, what are the next steps? So as Larry's mentioned and I've mentioned, we will have a public hearing to hear both the site plan review and the appeal, and that's scheduled for July 30th. And then following a decision on that, there would be a decision on the shoreline substantial development permit. That's an administrative decision that gets sent to the Department of Ecology. And then tonight, this is another note, just tonight we aren't taking any action on this project tonight, just a briefing. And then just to follow up one more time, just to let you know, everything I have put in this PowerPoint is also within the current written record, and so it does not go beyond that at this point in time.
Mr. President?
Yeah, Mr. Zwicker?
Vanessa, you mentioned that a staff report was done on July 2nd.
Yes.
Will that staff report be amended?
No. That staff report is related to the site plan, and the site plan was not appealed. The site plan hasn't been heard, or a decision hasn't been made on that yet. So that staff report's still consistent and fine in the way that it's set up. Yeah.
Thank you. That it?
Right.
Back, ma'am.
And I haven't seen that TV show, so.
Any,
Did good.
Any questions?
Great job.
Yeah, absolutely.
Just the facts.
Okay, well, yeah, okay.
All right.
Okay, with that, the committee of the whole is adjourned. We'll reconvene as a council at 7
Really would-
PM.